Well, at this point, it wouldn't be a Canadian citizen submitting to a foreign tribunal. It would be the government of Canada submitted to a tribunal over a decision made by a municipality, a province, the federal government, or a court. So the People's Republic of China, for instance, a real live example that I'm terrified about if they ratify this thing would be, we turn down Enbridge. Right? There's already money from Chinese state-owned enterprises in the development of the proposal for the pipeline. So then they could take us to an international tribunal. But it's not that they could
take... how could they subject some kind of an incorporated body in Canada to a foreign tribunal without any law behind it?
Because investment treaties work that way. And we've had, I mean, they are, my friend Stephen Schreiber, who's the lawyer for Council of Canadians, who, by the way, another thing's going on is the robocalls case he's taken. But years ago, when Stephen and I were working against the multilateral agreement on investment, and he had this great phrase, he described investor-state agreements such as Chapter 11 of NAFTA as fundamentally corrosive of democracy. I mean, these are outrageous treaties, regardless of what country we've signed on to these things.
Right.
The first one in the world, Chapter 11 of NAFTA, that said a U.S. or, for that matter, Mexican, as if that was going to happen, corporation with an investment in Canada, where they felt some action of the Canadian government was tantamount to expropriation, can sue us in an arbitration panel. And most of the cases that have come up under Chapter 11 of NAFTA have been health and environment cases, and we've lost quite a few. And that meant, but that was at least a U.S.-based corporation like Ethel Corporation of Richmond, Virginia, horrific company, manufactured lead and gasoline for years, still does and sells it to developing countries. For Canada, they were making a gasoline additive called MMT. We banned it. They took the case to an international arbitration tribunal, but at least it was the government of Canada sitting in arbitration tribunal against Ethel Corporation of Richmond, Virginia. The dynamic is entirely different when it's the People's Republic of China state-owned enterprises. So the treaty's drafted differently. The first 6 months of a complaint is now to be private diplomatic wrangling for 6 months, which Canadians might not even ever know has happened. And the People's Republic of China is going to be in a very different position from the Ethel Corporation. They're going to be able to say, in the diplomatic phase, if you don't change that law, well, we have a lot of investments in Canada, we might pull them. I mean, there's a very lopsided power relationship there. And so that's, these investor-state agreements are, in my view, all horrible. But when Canada signed on the bunch of recent ones, and the media doesn't really understand the difference. They ask me questions like, well, why are you so upset about the one with China instead of the other ones? I said, well, you know, I really wasn't worried about the one we signed with Trinidad and Tobago, or Ghana, or Costa Rica. I mean, bad news for those countries because Canadian mining companies can sue them, right? So it's quick, who has the economic clout, who's doing the investment, who's decided to make themselves a resource colony of a larger empire. This treaty makes us a resource colony of China. And it fundamentally undermines democracy. And it should be illegal, but it's not.